My Lord, public interest, I would want you to be guided on what the Supreme Court has said in petition number 10 and 11, consolidated of 2024. That is the case of Dock Workers Union and Okio Mutata versus APA and others.
Yes.
And Your Lordship, the Supreme Court will very granted, but the third ground that the court should consider while granting or denying conservatory orders is the impact of such orders beyond the parties to the case, and should the order be granted or denied, what is the public interest position?
Yes.
Your Lordship, the Supreme Court is urging you to kindly make a general inquiry as to what the public interest position is in this matter. My Lord, I will leave that to you by going through the motions filed before you, the replies and the submissions. My Lord, it's my humble submission that the public interest, as espoused by the people of Meru County through the elected members of the County Assembly,
Yes.
is that the governor has failed the test of public trust. My Lord, it is right that public interest overrides private interest. My Lord, again, I will urge you, the public interest in this matter, as connoted by the MCAs and as confirmed by the Senate, which again is exercising the sovereign power of the people. And Article 1, is that the petitioner before you has failed the question of integrity and all other offenses that he was found guilty of. My Lord, allow me to address you on the second point as to whether or not, if you don't extend or maintain the conservatory orders, this petition is going to be rendered nugatory. My Lord, we humbly submit that the position of a governor, with all due respect, Your Lordship, is not personal to any individual. It is a constitutional office. The holders of that office are public officers within the meaning of the law.
Yes.
My Lord, no person can claim or individualize the position of a governor. As such, Your Lordship, the law provides the mechanisms of removal of a governor. And that is exactly what has happened in the matter before you, my Lord. My Lord, it is trite, and the court was kind enough to read our minds, which is also in our submissions, that indeed, even if the governor was to be found to have a meritorious petition before you,
Yes.
you have powers to reinstate her in office. My Lord, you have powers to order that she be paid damages. My Lord, again, you have powers to issue any appropriate orders that will remedy her as a person of the government. My Lord, as such, Article 182, sub-Article 2 of the Constitution also provides why there will be no vacuum, because a deputy governor will be able to take office and discharge the functions of a governor. As such, Your Lordship, there is no issue of nugatory or the petitioner or the petition being rendered nugatory before you, because the law has provided safeguards, sufficient safeguards over such a matter.
Yes.
My Lord, if you allow me again, I had my colleagues submit that there is no way of dealing with a deputy governor who assumes office. My Lord, I would want to refer you to Article 182 provides that a deputy governor can as well be removed.
Article 182 clause 6.
Article 6.
Yes.
Which, my lord, provides that a deputy governor can as well be removed if he does not act within the constitution provisions. My lord, we've also been told that the petition will be rendered nugatory because the county executive committee and the cabinet will be kicked out of the office because the governor has been removed. My lord, with all due respect, that position is inaccurate. Those persons are positional office holders, elected or nominated or given that power pursuant to legal provisions. In fact, their terms run for 5 years. And my lord, the mere taking of the office by the deputy governor does not mean that those persons will as well go home. My lord, we've also been heard that in regard to section 33(8) of the County Government Act, and my lord, is a humble submission before you that that provision of the law enjoys the presumption of constitutionality. My lord, in any event, with all due respect again, the issue of section 33(8) is the thrust of the petition in Meru, which is still pending and which has not been prosecuted. My lord, with all due respect, without going into the facts of the matter as an interested party, you are urged that there was an existing court order barring the impeachment process. My lord, our first question is, was the Senate a party to those proceedings? My lord, our second question is, if indeed there were proceedings that barred the impeachment process, has the petitioner filed any contempt application in that court? And my lord, if they want you to deal with the issues of section 33(8) of the County Government Act, they sought a consolidation of the two petitions so that this court is then embodied to deal with that issue. But with all due respect, we feel that those facts have not been brought before you in the proper way, and you're being enjoined and you're being misled with all due respect, where there is not material disclosure of the proper facts on the ground, and upon which your lordship was misled to issue a conservatory order. But as I wind up argument on that point, I wish to remind ourselves that the term of the petitioner as an elected governor is not indefinite. It's only limited to 5 years. The law anticipated that that term can be stopped or curtailed through a legal process. That is what has happened, Your Lordship, and there is nothing illegal about that. A such petition before you cannot be said that it will be rendered nugatory when a legal process has taken place. My Lord, allow me to go into the question of balance of convenience.
Yes.
Your Lordship, allow me to pose a question. What would happen if Your Lordship maintains the conservatory orders in this matter and eventually finds that the petition before you is not merited? My Lord, the people of Meru, the voters of Meru, one of whom I represent before you, will continue the suffering they have endured since the governor took office, and they are enduring in the current stalemate in Meru County.
Your Lordship, I object to that. a learned colleague like my other learned colleague did file an affidavit. The question of people of Meru suffering is a purely factual issue that can only be brought to the attention of this court or of an affidavit. I urge that it is stopped in its tracks from submitting such a factual issue to that affidavit, because we want to know the particulars of suffering so that we deal with them one by one.
Mr. Karimi,
Yes, Your Lordship.
please limit yourself to the scope of the submissions.
Thank you, my Lord. I will limit myself. I'd like Your Lordship to look at the facts from the parties who have filed affidavits of fact. Thank you. My Lord, on the matter of convenience, I was submitting that in the event that you find that this petition was not merited, and by that time, the voters of Meru County will have endured the lack of a proper governor for the county. And that, my Lord, with God due respect.
Mr. Karimi,
Yes, sir.
Mr. Ngoy has not raised his feet, but I think you can reword that. You can reword that submission.
Thank you, Lord. Thank you, Lord. My Lord, allow me to give that and move to the second week of argument, where the balance of arguments favors the lifting of the conservative leaders.
Yes.
My Lord, we humbly submit that it will have been, with all due respect, unfair to the people of Meru County to have endured a process whereas they could have sworn in the deputy governor and proceeded with the management of the county affairs, while the governor finds justice in the petition before you. Because the conservative ordered the elections. My Lord, with all due respect, we also want to repeat the question of the status quo